Job Kijja is my name. I'm a civic activist, I'm a human rights defender, and I'm a governance researcher. My understanding of the Protection of Sovereignty Act is that it actually has two phases. The first phase is what it is purported to be. And what it is purported to be, according to the government, is that this is a law that protects Uganda from Uganda sovereignty from foreign interference, from saboteurs, etc. Okay, and they tend to give say a lot of things about our colonial history, about imperialists having interfered with Uganda in the past, and apparently they've been continuing to interfere. The reality is that when you read the letter and the spirit of the law, it actually doesn't say anything about Uganda's sovereignty. Because Uganda is not about just the land. Uganda, what makes Uganda is the people. The law does not say anything about protecting the sovereignty of the Ugandan people. If anything, it talks about protecting the sovereignty of the Ugandan state, which state should be subordinate to Ugandan citizens. But if you look at this law, it is actually making Ugandan citizens subordinate to the Ugandan state. Okay? And for me, I think that is the unfortunate thing about this law. If you read it, it says nothing about protecting Ugandans. If anything, it is talking about oppressing Ugandans. So the text and spirit and even all the provisions in that law actually take away sovereignty from the citizens of Uganda. It does nothing to protect them. The initial text actually was even taking away the citizenship of Ugandans, because it was declaring citizens that are living outside Uganda as foreigners. This is the only law like that. It is only the text of the bill in Uganda that was stripping citizens of their citizenship, merely because they have gone to stay outside Uganda. Secondly, the law, as is at the moment, is creating a lot of red tape in terms of facilitation for citizen organizing and even organizing of the opposition. Okay? Uganda's law, the supreme law in Uganda, which is the constitution of Uganda, clearly provides for a multi-party dispensation. Multi-party dispensation is a system whereby you recognize the existence of a ruling party and opposition groups. But what this law does is basically to declare any work to do with the opposition as illegal. Uganda's law clearly provides, the supreme law again, the constitution, clearly provides for civil society organizing, for citizens to organize, for citizens to defend the constitution. What this law does, actually, for citizens to even participate in government, in policy making, in policy implementation. What this law does is that it takes away that right, which is inherently provided by the constitution. So this act actually is rewriting the constitution. It is such a bad law, it is an evil law, which actually does not deserve to be even anywhere in the law books of Uganda. The second question that you ask in terms of the process, people say that the origin of this law is from the NGO funding law, which I think is not true, because at least what I have come to learn is that sometime around the elections, there are some individuals that were not happy with the manner in which the opposition had organized, and then they tried to blame that actually on civil society. A lot of lies were told that funding for the opposition was actually coming through civil society, and there's no evidence to that effect. Much as some people say they have evidence, because the people I have talked to, I have asked them, but do you really have evidence? And when they say yes, you say, okay, please, at least let us have a look at it. And there's nothing that they can show. So because of that, people told lies to the president, and they said the opposition funding has been coming through civil society. I have followed the politics in this country. I have followed the campaign trail. I have talked to people in the opposition, I have talked to people in government, I have talked to people in civil society, and I know that that money is not there. That the money they are talking about never even made it to this country, because the opposition was really struggling. The manner in which laws are presented in this country and passed is known. All the norms were breached. Why do I say they were breached? They were breached because laws are supposed to be debated by members of parliament. This law never went through a committee process. They conducted public hearings, came up with a report of the committee. When they went to committee stage to discuss the committee report, the military was brought in and it stopped them from debating the committee report. And then the process was circumvented and the government introduced a new law, okay, which was never tabled on the floor of parliament. And it forced the committee to actually adopt this law at gunpoint because the military was there. Okay, that is not how committee business is conducted. There was even a fight. The members of the opposition that are members of that committee were chased away. They were not allowed. So no debate happened on that law at committee stage. When the law was taken to the House, the committee of the whole House, again it was not debated. There were 6 minority reports. People that were dissenting and saying no. This is actually the first time that there has been more than 1 minority report. Usually it is 1, and in some instances there's none. But there were 6 minority reports, and she never allowed these reports to be discussed on the floor of parliament. Even the main report which was presented by the committee was never debated. They simply read clauses and they were passed as is. And then they gave it to us as their, they were calling it, I think, term agenda, something like that. So, this protection of sovereignty bill, which actually is the misappropriation of citizen sovereignty, is a law that we have in place that shouldn't be anywhere on the law books of Uganda. Okay? This is the first piece of legislation that has drawn as much attention from Ugandans. There were over 200 memoranda submitted by Ugandans from all walks of life. Okay? From the diaspora, domestic workers, elderly people, religious institutions, civil society organizations, citizens from all the 15 regions that negotiated independence. All of them submitted memoranda. Government institutions, the Bank of Uganda is on record, okay? And they said this is not about citizen sovereignty. This law is taking away citizen sovereignty. Private sector, the bankers, everybody submitted memoranda. 98% of the 200 memoranda, all of them rejected this law. We did an analysis and it was doing the work of at least 10 other laws, okay? Then number 2, we did a comparison with other laws that talk about citizen sovereignty across the board. The laws that the government was saying that they had benchmarked on in terms of the countries, the US and Canada and wherever, there was no similarity between the laws of those countries and the text that was provided in the bill and now finally in the act. If you read this law, you'll actually see that it mirrors laws in countries like Nicaragua, Azerbaijan, Georgia, Hungary, Russia, and all these are autocracies. Now the question is, why is Uganda, that claims to be a democracy, borrowing laws from autocratic countries? Does Uganda want to become an autocracy? If Uganda wants to become an autocracy, let it amend our constitution and declare that actually we are now an autocracy. But also, the current regime actually has the leeway to suspend the constitution and declare rule by law and declare a life presidency like Amin did and say we are now no longer a democracy, we are now an autocracy.